The era of digital resurrection has hit a massive legal wall. Just hours ago, a federal court in California issued a nationwide preliminary injunction against Elysium AI Studios. The judge ruled that their Legend series, which features a hyper-realistic digital clone of the late Robin Williams, violates the newly established federal right to publicity. This isn't just about copyright, it's about digital identity. The court stated that a person's voice and persona are not just data, they are an extension of their personality that survives death. For years, Elysium AI operated in a gray zone, using thousands of hours of Williams' private recordings and film outtakes to train their model for a series of interactive AI comedy specials. But today, Zelda Williams and the actor's estate won a decisive victory. Zelda's statement, released just minutes after the verdict, was clear. "My father's soul is not a subscription service." Judge Sarah Evans delivered a 45-page opinion that sent shockwaves through Silicon Valley. She wrote, "The dead do not lose their humanity simply because they can be reduced to binary code. To simulate a person's creative spark without consent is not innovation. It is digital grave robbing." The injunction effectively halts the distribution of any AI model that hasn't been vetted by the heirs. Silicon Valley is in a state of absolute panic. Tech leaders fear that any voice that sounds too similar to a known figure could now trigger a multi-million-dollar lawsuit. In 2026, the dead are reclaiming their voices, and the era of unrestricted digital ghosts is officially over. Late last night, February 4th, 2026, a jury in Illinois delivered a verdict against Amazon that will change every American household forever. The tech giant was found liable for unauthorized acoustic surveillance through its Alexa devices, a ruling that shatters the defense of fine print user agreements. The case centered on a hidden feature internally known as Project Emotional Sync. For the first time, the public saw internal memos from 2024 proving that Alexa was programmed to do more than just listen for commands. The system was actively and covertly analyzing the emotional state of users, detecting stress, depression, or even excitement through subtle changes in vocal pitch, speech cadence, and breathing patterns. Amazon didn't just store this data, they weaponized it for hyper-targeted marketing. The prosecution presented evidence that this emotional metadata was categorized and sold to third-party advertisers in real time. This allowed brands to target users at their most psychologically vulnerable moments. We are talking about ads for comfort food popping up on a phone the moment Alexa sensed a user sounded depressed, or high-interest predatory loans being offered via email to a person whose voice signaled extreme financial anxiety during a private conversation at home. Amazon's defense was built on the argument that users consented to data collection by setting up the device and clicking, "I agree." But the jury wasn't buying the idea that an invisible algorithm can strip away constitutional rights. Judge Marcus Thorne, in his final remarks, stated that a reasonable expectation of privacy within one's home cannot be waived by a 50-page digital contract that no one reads. He described Amazon's tactics as predatory and deceptive data harvesting. The $2 billion penalty is a historic message to big tech. Your living room is not a laboratory for psychological profiling. This verdict effectively creates a new legal standard for informed consent in the age of ambient computing. While Amazon has already announced an immediate appeal today, February 5th, the legal precedent is now a reality. In 2026, the walls of the American home are finally being reinforced against the ears of Silicon Valley. What happens in your private life is no longer a commodity for sale. In a surprising move this afternoon, February 5th, the Supreme Court declined to hear an appeal regarding the case of Texas versus Dr. Alan Braid. By refusing to intervene, the highest court has effectively triggered a constitutional crisis that many feared was inevitable. This decision allows a massive multi-million-dollar lawsuit against the California-based physician to proceed in a Texas courtroom. Dr. Alan Braid is accused of violating Texas state law, specifically the controversial SB 8, by mailing abortion medication to Texas residents from his medical office in San Francisco. What makes this case a legal nightmare is the private bounty system. Under SB 8, any private citizen, even those with no connection to the patient, can sue a person they believe aided or abetted an abortion, seeking damages of at least $10,000 per claim. In this case, Texas is seeking over $10 million, a sum designed to bankrupt Dr. Braid and serve as a warning to any other provider in a safe state. California's response was SB 345, a shield law specifically designed to protect its doctors from such out-of-state prosecutions. It forbids California courts and law enforcement from cooperating with Texas authorities. But today's Supreme Court silence creates a dangerous void. It leaves a doctor in a shield state like California completely vulnerable to the laws of a state they never stepped foot in. Legal experts warn that this isn't just about reproductive rights. It's about the full faith and credit clause of the Constitution. If Texas can reach across state lines to punish a California doctor for an act that is perfectly legal in California, then the border between states is effectively becoming a legal iron curtain. In 2026, we are witnessing the balkanization of American law. If Dr. Braid loses this $10 million battle, it won't just be his bank account that is destroyed. It will be the very idea of a unified legal system in the United States. That was the Verdict Court News. Thank you for watching. Stay with us as we continue to regularly cover the most critical cases and high-profile decisions from courtrooms across the nation. Don't forget to subscribe to our channel to never miss an update on the cases that matter. Until next time.